In reality, petitioners have been unable to attend supervised visits due to the unavailability of the designated facility, SPCC or equivalent, to provide supervision. Respondents' active evasion of Child Protective Services obstructing alternate supervision arrangements. Respondents' conduct constitutes parental interference and violates petitioners' rights under the 14th Amendment. Okay. Concerns regarding respondents' conduct. Lack of stable housing. Respondents' cross-country relocations demonstrate instability contrary to the best interest standard under the FCA. Violation of the court's orders. Respondents' actions flout the August 9, 2024 order, which prohibited interstate removal, required cooperation and visitation, and then mandated stable residency in Monroe County. The legal defect, the custody award, is voidable under the FCA Article 5, as respondent's paternity was never adjudicated or acknowledged. Relief requested. Petitioner respectfully requests that this court enforce the existing order barring respondent from removing the child of Monroe County. Order respondent to immediately return the child to Monroe County. Hold the respondent in contempt for violating the court's orders and interfering with visitation. Expedite proceedings to vacate the custody award pending paternity adjudication under the FCA Article 5 and restore the petitioner's custodial rights under the FCA 651. Grant any further relief the court deems just. The August 9th custody order is procedurally defective and must be vacated due to the failure to establish Ronald Contreras' legal parentage prior to the court's award of custody. Under the Family Court Act, Article 5 legal parentage must be established through formal process, such as a signed birth certificate acknowledgement, DNA test, an affidavit of parentage, or judicial declaration. I don't know where I got judicial from. Declaration of paternity. In the case at hand, no such formal procedures were followed. Contreras was never adjudicated as the legal father of Sevyn Moon, nor was his paternity acknowledged by any legal mechanism, as established in matter of Juanita versus Kenneth, Mark, etc., and Jean versus this person, whatever. Custody determination required legally recognized parent-child relationship, which cannot exist absent a formal paternity establishment. Therefore, the family court acted ultra vires, whatever, meaning like out of line, in granting custody to Contreras without the requisite adjudication of paternity. The lack of legal parentage deprives the court of jurisdiction to award custody, rendering the August 9th order voidable. Accordingly, petitioner respectfully requests that this court vacate the order and restore her custodial rights. Wherefore, the petitioner respectfully requests that this court grant the relief in herein and any other relief deemed proper. So basically, we've been going back and forth about how, Ronald's been in contempt of this order. I need this modified, et cetera, and the court has been retaliating against me. They have been, delaying my proceedings, et cetera, And now that I have a new judge, this is new eyes. She doesn't know me. I don't know her. We're hoping that this can, be moved on procedurally and that she won't fall in line with the ways that everybody has retaliated. Also being now that there is a brief filed by my attorney that says basically what she did wrong, right? So this brings it all down. I'm not going to read the whole thing. Like I said, it's available. But essentially that the record lacks a sound and substantial basis in the record. The evidence within the record supports granting respondent petitioner, which is me, mother, primary residential custody. The trial court admitted irrelevant social media evidence. The trial court admitted social media evidence without the proper foundation being established. The trial court improperly admitted social media evidence that was unfairly prejudicial to the respondent appellate mother. The court erred in conferencing with the Court of Common Pleas of Pennsylvania by failing to do so on the record, depriving the parties of due process of law. So when I say what she did was bad, it was bad.